Hello, welcome to part 2 of this reading the Bills of Exchange Act 1985. If you are looking to go through the entire act, you can go to part 1. There may be a part 3 unless I get through all of it in part 2. So, we left off at Notice of Dishonor. Notice of Dishonor. Subject to this act, when a bill has been dishonored by non-acceptance or by non-payment, notice of dishonor must be given to the drawer and each endorser, and any drawer or endorser to whom the notice is not given is discharged. Subsequent holder. Where a bill is dishonored by non-acceptance and notice of dishonor is not given, the rights of a holder in due course subsequent to the omission are not prejudiced by the omission. Notice of subsequent dishonor. Where a bill is dishonored by non-acceptance and due notice of dishonor is given, it is not necessary to give notice of a subsequent dishonor by non-payment unless the bill is accepted in the meantime. Notice to acceptor. In order to render the acceptor of a bill liable, it is not necessary that notice of dishonor be given to him. Conditions for validity of notice. Notice of dishonor, in order to be valid and effectual, must be given. A. Not later than the juridical or business day next following the dishonoring of the bill. B. By or on behalf of the holder, or by or on behalf of an endorser, who at the time of giving notice is himself liable on the bill. C. In the case of the death, if known to the party giving notice of the drawer or endorser, to a personal representative if there is one, and with the exercise of reasonable diligence he can be found. And D. In case of two or more drawers or endorsers who are not partners to each of them, unless one of them has authority to receive notice for the others. How notice given? 1. Notice of dishonor may be given, A. As soon as the bill is dishonored. B. To the party to whom notice is required to be given, or to his agent in that behalf. C. By an agent either in his own name or in the name of any party entitled to give notice, whether that party is his principal or not. D. In writing or by personal communication, and in any terms that identify the bill and intimate that the bill has been dishonored by non-acceptance or non-payment. Misdescription. A misdescription of the bill does not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. Form of notice. In point of form, the return of a dishonored bill to the drawer or endorser is a sufficient notice of dishonor, and a written notice need not be signed. Verbal supplement. An insufficient written notice may be supplemented and validated by verbal communication. Okay, notice by agent. Where a bill, when dishonored, is in the hands of an agent, he may himself give notice to the parties liable on the bill, or he may give notice to his principal, in which case the principal on receipt of the notice has the same time for giving notice as if the agent had been an independent holder. Okay, time for notice. Where the agent gives notice to his principal, he must do so within the same time as if he were an independent holder. Notice to antecedent parties. Where a party to a bill receives due notice of dishonor, he has, after the receipt of the notice, the same period of time for giving notice to antecedent parties that a holder has after dishonor. Benefit of notice. A notice of dishonor ensures for the benefit A. Of all subsequent holders and of all prior endorsers who have a right of recourse against the party to whom the notice is given, where given on behalf of the holder, and B. Of the holder and all endorsers subsequent to the party to whom the notice is given, where given by or on behalf of an endorser entitled under this part to give notice. So this is for the benefit of notice to all subsequent holders and of the holders okay. How notice addressed. Notwithstanding anything in this act, notice of dishonor of any bill payable in Canada is sufficiently given if it is addressed in due time to any party to the bill entitled to the notice, at his customary address or place of residence, or at the place at which the bill is dated, unless any such party has, under his signature, designated another place in which the notice shall be sufficiently given if addressed to him in due time at that other place. Sufficiency of notice. A notice referred to in subsection 1 shall be sufficient, although the place of residence of such party other than either of the places mentioned in that subsection, and shall be deemed to have been duly served and given for all purposes if it is deposited in any post office with the postage paid thereon at any time during the day on which presentment has been made or on the next following juridical or business day. Death of party. The notice referred to in subsection 1 is not invalid by reason only of the fact that the party to whom it is addressed is dead. Miscarriage in post service. Where a notice of dishonor is duly addressed and posted as provided in section 102, the sender is deemed to have given due notice of dishonor, notwithstanding any miscarriage by the post office. Excuse for delay. Delay in giving notice of dishonor is excused where the delay is caused by circumstances beyond the control of the party giving notice, and not imputable to his default, misconduct, or negligence. Diligence. Where the cause of delay in giving notice of dishonor ceases to operate, the notice must be given with reasonable diligence. Notice dispensed with. Notice of dishonor is dispensed with, a. when the exercise of reasonable diligence, notice as required by this act cannot be given to or does not reach the drawer or endorser sought to be charged, or b. by waiver, express or implied. When after the exercise of reasonable diligence, notice as required by this act cannot be given. Okay. Time of waiver. Notice of dishonor may be waived before the time of giving notice has arrived or after the omission to give due notice. Dispensing with notice redrawer. Notice of dishonor is dispensed with as regards the drawer where a. the drawer and drawee are the same person, b. the drawee is a fictitious person or a person not having capacity to contract, c. the drawer is the person to whom the bill is presented for payment, d. the drawee or acceptor as between himself and the drawer under no obligation to accept or pay the bill. The drawee or acceptor is as between himself and the drawer under no obligation to accept or pay the bill. Or e. the drawer has countermanded payment. Okay. Dispensing with notice re-endorser. Notice of dishonor is dispensed with as regards the endorser where a. the drawee is a fictitious person or a person not having capacity to contract, and the endorser was aware of the fact at the time he endorsed the bill. The endorser is the person to whom the bill is presented for payment. Or c. the bill was accepted or made for his accommodation. Okay. Protest. Necessity of protest. In order to render the acceptor of a bill liable, it is not necessary to protest it. Protest dispensed with. Protest is dispensed with by any circumstances that would dispense with notice of dishonor. Delay excused. Delay in noting or protesting is excused where the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. Diligence. Where the cause of delay in noting or protesting ceases to operate, the bill must be noted or protested with reasonable diligence. Foreign bill, non-acceptance. Where a foreign bill appearing on the face of it to be such has been dishonored by non-acceptance, it must be duly protested for non-acceptance. Non-payment. Where a foreign bill that has not been previously dishonored by non-acceptance is dishonored by non-payment, it must be duly protested for non-payment. Balance. Where a foreign bill has been accepted only as to part, it must be protested as to balance. Okay. Discharge. Where a foreign bill is not protested as required by the section, the drawer and endorsers are discharged. Protest of inland bill. Where an inland bill has been dishonored, it may, if the holder thinks fit, be noted and protested for non-acceptance or non-payment, as the case may be, but it is not necessary to note or protest an inland bill in order to have recourse against the drawer or endorsers. Protest unnecessary. Where a bill does not on the face of it appear to be a foreign bill, protest thereof in case of dishonor is unnecessary. Subsequent protest for non-payment. A bill that has been protested for non-acceptance or a bill of which protest for non-acceptance has been waived may be subsequently protested for non-payment. Protest for better security. Where the acceptor of a bill suspends payment before it matures, the holder may cause the bill to be protested for better security against the drawer and endorsers. Acceptance for honor. Where a dishonored bill has been accepted for honor under protest or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor or referee in case of need. Protest for non-payment. When a bill is dishonored by the acceptor for honor, it must be protested for non-payment by him. Noting equivalent to protest. For the purposes of this act, where a bill is required to be protested within a specified time or before some further proceeding is taken, it is sufficient that the bill has been noted for protest before the expiration of the specified time or the taking of the proceeding. Protest on day of dishonor. Subject to this act, when a bill is protested, the protest must be made or noted on the day of its dishonor. Extending protest. When a bill has been duly noted, the formal protest may be extended thereafter at any time as of the date of the noting. Protest on copy or particulars. Where a bill is lost or destroyed or is wrongly or accidentally detained from the person entitled to hold it or is accidentally retained in a place other than where payable, protest may be made on a copy or written particulars thereof. Place of protest. A bill must be protested at the place where it is dishonored, or at some other place in Canada situated within 5 miles of the place of presentment and dishonor of the bill. Where bill returned by post. When a bill is presented through the post office and returned by post dishonored, it may be protested at the place to which it is returned, not later than on the day of its return or the next juridical day. Time of protest. Every protest for dishonor, either for non-acceptance or non-payment, may be made on the day of the dishonor, and in case of non-acceptance at any time after non-acceptance, and in case of non-payment at any time after 3 o'clock in the afternoon local time. Contents of the protest. A protest must contain a copy of the bill, or the original bill may be annexed thereto, must be signed by the notary making it, and must specify A. the person at whose request the bill is protested, B. the place and date of protest, C. the cause or reason for protest, and D. the demand made and the answer given, if any, or the fact that the drawee or acceptor could not be found. When notary not accessible. Where a dishonored bill is authorized or required to be protested and the services of a notary cannot be obtained at the place where the bill is dishonored, any justice of the peace resident in the place may present and protest the bill and give all necessary notices and has all the necessary powers of a notary with respect thereto. Expense. The expense of noting and protesting any bill and the postages thereby incurred shall be allowed and paid to the holder in addition to any interest thereon. Notaries' fees. Notaries may charge the fees in each province allowed them. Forms. The forms in the schedule may be used in noting or protesting any bill and in giving notice thereof. Annexing copy or original of bill. A copy of the bill and endorsement may be included in the forms, or the original bill may be annexed and the necessary changes in that behalf made in the forms. How notice of protest given. Notice of the protest of any bill payable in Canada is sufficiently given and is sufficient and deemed to have been duly given and served if given during the day on which protest has been made or on the next following juridical or business day. to the same parties and in the same manner and addressed in the same way as is provided by this part for notice of dishonor. Alright, next big section, liabilities of parties. Equitable assignment. A bill of itself does not operate as an assignment of funds in the hands of the drawee available for the payment thereof, and the drawee of a bill who does not accept as required by this act is not liable on the instrument. Engagement by acceptance. The acceptor of a bill, by accepting it, engages that he will pay it according to the tenor of his acceptance. Whoa. Estoppel. The acceptor of a bill, by accepting it, it is precluded from denying to a holder in due course a. the existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the bill. B. in the case of a bill payable to drawer's order, the then capacity of the drawer to endorse, but not the genuineness or validity of his endorsement. Or C. in the case of a bill payable to the order of a third person, the existence of the payee and his then capacity to endorse, but not the genuineness or validity of his endorsement. Drawer. The drawer of a bill, by drawing it, engages that on due presentment it shall be accepted and paid according to its tenor, and that if it is dishonored he will compensate the holder or any endorser who is compelled to pay it, if the requisite proceedings on dishonor are duly taken. And B. is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. Liability by signature. No person is liable as drawer, endorser, or acceptor of a bill who has not signed it as such. But when a person signs a bill otherwise than as a drawer or acceptor, he thereby incurs the liabilities of an endorser to a holder in due course, and is subject to all the provisions of this act respecting endorsers. Where a person, trade name or assumed name. Where a person signs a bill in a trade name or assumed name, he is liable thereon as if he had signed it in his own name. Firm name. The signature of the name of a firm is equivalent to the signature by the person so signing of the names of all persons liable as partners in that firm. Endorser. The endorser of a bill, by endorsing it, subject to the effect of any express stipulation authorized by this act, A. engages that on due presentment it shall be accepted and paid according to its tenor, and that if it is dishonored he will compensate the holder or a subsequent endorser who is compelled to pay it, if the requisite proceedings on dishonor are duly taken. B. is precluded from denying to a holder in due course the genuineness and regularity in all respects of the drawer's signature and all previous endorsements. And C. is precluded from denying to his immediate or a subsequent endorsee that the bill was, at the time of his endorsement, a valid and subsisting bill, and that he had then a good title thereto. Measure of damages. Where a bill is dishonored, the measure of damages, which shall be deemed to be liquidated damages, are A. the amount of the bill, B. interest thereon from time of presentment for payment if the bill is payable on demand, and from the maturity of the bill in any other case, and C. the expenses of noting and protesting. Recovery of damages. In the case of a bill that has been dishonored, the holder may recover from any party liable on the bill. The drawer who has been compelled to pay the bill may recover from the acceptor, and an endorser who has been compelled to pay the bill may recover from the acceptor or from the drawer or from a prior endorser. The damages prescribed in section 133. Re-exchange and interest. In the case of a bill that has been dishonored abroad, in addition to the damages prescribed in section 133, the holder may recover from the drawer or any endorser, and the drawer or an endorser who has been compelled to pay the bill may recover from any party liable to him the amount of the re-exchange with interest thereon until the time of payment. Transfer by delivery. Where the holder of a bill payable to bearer negotiates it by delivery without endorsing it, he is called a transferor by delivery. Liability of transferor. A transferor by delivery is not liable on the instrument. Warranty by transferor. A transferor by delivery who negotiates a bill thereby warrants to his immediate transferee, being a holder for value, that A. the bill is what it purports to be, B. he has a right to transfer it, and C. at the time of the transfer he is not aware of any fact that renders it valueless. Okay. Discharge of bill. Payment. A bill is discharged by payment in due course by or on behalf of the drawee or acceptor. Payment in due course. Payment in due course means payment made at or after the maturity of the bill to the holder thereof in good faith and without notice that his title to the bill is defective. Accommodation bill. Where an accommodation bill is paid in due course by the party accommodated, the bill is discharged. Payment by drawer or endorser. Subject to the provisions of Section 138 with respect to an accommodation bill, when a bill is paid by the drawer or endorser, it is not discharged, but A. where a bill payable to or to the order of a third party is paid by the drawer may enforce payment thereof against the acceptor, but may not reissue the bill, and B. where a bill is paid by an endorser, or where a bill payable to drawer's order is paid by the drawer, the party paying it is remitted to his former rights as regards the acceptor or antecedent parties, and he may, if he thinks fit, strike out his own and subsequent endorsements and again negotiate the bill. Wow. Acceptor holding at maturity. When the acceptor of a bill is or becomes the holder of it at or after its maturity in his own right, the bill is discharged. Renouncing rights. When the holder of a bill at or after its maturity absolutely and unconditionally renounces his rights against the acceptor, the bill is discharged. Against one party. The liabilities of any party to a bill may in like manner be renounced by the holder before, at, or after its maturity. In writing. A renunciation must be in writing unless the bill is delivered to the acceptor. Holder in due course. Nothing in this section affects the rights of a holder in due course without notice of renunciation. Okay. Cancellation of bill. Where a bill is intentionally canceled by the holder or his agent and the cancellation is apparent thereon, the bill is discharged. Of any signature. In like manner, any party liable on a bill may be discharged by the intentional cancellation of his signature by the holder or his agent. Discharge of endorser. In any case described in subsection 2, any endorser who would have had a right of recourse against the party whose signature is canceled is also discharged. Unintentional cancellation. A cancellation made unintentionally or under a mistake or without the authority of the holder is inoperative, but where a bill or any signature thereon appears to have been canceled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally or under a mistake or without authority. Alteration of bill. 1. Subject to subsection 2, where a bill or an acceptance is materially altered without the assent of all parties liable on the bill is voided except as against a party who has himself made, authorized, or assented to the alteration and subsequent endorsers. Let me read that again. Alteration of bill. Subject to subsection 2. So where's subsection 2? Is that of the cancellation? Subject to subsection 2, where a bill or an acceptance is materially altered without the assent of all parties liable on the bill is voided, except as against a party who has himself made, authorized, or assented to the alteration and subsequent endorsers. Right of holder in due course. Where a bill has been materially altered, but the alteration is not apparent, and the bill is in the hands of a holder in due course, the holder may avail himself of the bill as if it had not been altered and may enforce payment of it according to its original tenor. Material alteration, in particular, any alteration of the date of the sum payable, of the time of payment, of the place of payment, or by the addition of a place of payment without the acceptor's assent where a bill has been accepted generally, is a material alteration. Next big section, acceptance and payment for honor. Acceptance for honor under protest. Where a bill of exchange has been protested for dishonor by non-acceptance or protested for better security and is not overdue, any person not being a party already liable thereon may, with the consent of the holder, intervene and accept the bill under protest for the honor of any party liable thereon or for the honor of the person for whose account the bill is drawn. In part, a bill may be accepted for honor for part only of the sum for which it is drawn. Deemed to be for honor of drawer, where an acceptance for honor does not expressly state for whose honor it is made, it is deemed to be an acceptance for the honor of the drawer. Maturity of after-sight bill. Where a bill payable after sight is accepted for honor, its maturity is calculated from the date of protesting for non-acceptance and not from the date of the acceptance for honor. Requirements. An acceptance for honor under protest, in order to be valid, must be written on the bill and indicated that it is an acceptance for honor and be signed by the acceptor for honor. Liability of acceptor for honor. The acceptor for honor of a bill by accepting it engages that he will, on due presentment, pay the bill according to the tenor of his acceptance, if it is not paid by the drawee, if it has been duly presented for payment and protested for non-payment, and if he receives notice of those facts. If it has been duly presented for payment and protested for non-payment, and if he receives notice of those facts. Okay. Liability to holders and others. The acceptor for honor is liable to the holder and to all parties to the bill subsequent to the party for whose honor he has accepted. Payment for honor under protest. Where a bill has been protested for non-payment, any person may intervene and pay it under protest for the honor of any party liable thereon or for the honor of the person for whose account the bill is drawn. If more than one offer. Where two or more persons offer to pay a bill for the honor of different parties, the person whose payment will discharge most parties to the bill has the preference. Refusal to receive payment. Where the holder of a bill refuses to receive payment under protest, he loses his right of recourse against any party who would have been discharged by that payment. Entitled to the bill. The payer for honor, on paying to the holder the amount of the bill and the notarial expenses incidental to its honor, is entitled to receive both the bill itself and the protest. Liability for refusing. Where the holder does not on demand, in a case described in subsection 4, deliver up the bill and protest, he is liable to the payer for honor in damages. Attestation of payment for honor. Payment for honor under protest, in order to operate as such and not as a mere voluntary payment, must be attested by a notarial act of honor, which may be appended to the protest or form an extension of it. Declaration. The notarial act of honor must be founded on a declaration made by the payer for honor, or his agent in that behalf, declaring his intention to pay the bill for honor and for whose honor he pays. Discharge and subrogation. Where a bill has been paid for honor, all parties subsequent to the party for whose honor it is paid are discharged, but the payer for honor is subrogated for and succeeds to both the rights and duties of the holder with respect to the party for whose honor he pays, and all parties liable to that party. Lost instruments. Holders to have duplicate of lost bill. Where a bill has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer, if required, to indemnify him against all person whatever in case the bill alleged to have been lost is found again. Refusal. Where the drawer on request refuses to give a duplicate bill, he may be compelled to do so. Action on lost bill. In any action or proceeding on a bill, The court or a judge may order that the loss of the instrument shall not be set up, if an indemnity is given to the satisfaction of the court or judge against the claims of any other person on the instrument in question. Bill in a set. Bills in a set. Where a bill is drawn in a set, each part of the set being numbered and containing a reference to the other parts, the whole of the parts constitute one bill. Acceptance. The acceptance may be written on any part, but it must be written on one part only. Endorsing more than one part, where the holder of a set endorses two or more parts to different persons, he is liable on every such part, and every endorser subsequent to him is liable on the part that he has himself endorsed, as if the parts were separate bills. Negotiation to different holders. Where two or more parts of a set are negotiated to different holders in due course, the holder whose title first accrues is, as between such holders, deemed the true owner of the bill, but nothing in the subsection affects the rights of a person who in due course accepts or pays the part first presented to him. Accepting more than one part. Where the drawee accepts more than one part and such accepted part get into the hands of different holders in due course, he is liable on every such part as if it were a separate bill. Payments without delivery. When the acceptor of a bill drawn in a set pays it without requiring the part bearing his acceptance to be delivered up to him, and that part at maturity is outstanding in the hands of a holder in due course, he is liable to the holder thereof. Discharge. Subject to this section, where any one part of a bill drawn in a set is discharged by payment or otherwise, the whole bill is discharged. Conflict of laws. Requisites of forms. Subject to subsections 2 and 3, where a bill drawn in one country is negotiated, accepted, or payable in another, the validity of the bill with respect to requisites in form is determined by the law of the place of issue, and the validity with respect to requisites in form of the supervening contracts, such as endorsement, acceptance, or acceptance under protest, is determined by the law of the place where the contract was made. Unstamped bills. Where a bill is issued outside Canada, it is not invalid by reason only that it is not stamped in accordance with the law of the place of issue. Conforming to the law of Canada. Where a bill issued outside Canada conforms with respect to requisites in form to the law of Canada, it may, for the purpose of enforcing payment thereof, be treated as valid as between all persons who negotiate, hold, or become parties to it in Canada. Law applicable. Subject to this act, the interpretation of the drawing, endorsement, acceptance, or acceptance under protest of a bill drawn in one country and negotiated, accepted, or payable in another is determined by the law of the place where the contract is made. But where an inland bill is endorsed in a foreign country, the endorsement shall, with respect to the payer, be interpreted according to the law of Canada. Law as to duties of holder. The duties of the holder with respect to presentment of a bill for acceptance or payment, and the necessity for or sufficiency of a protest or notice of dishonor are determined by the law of the place where the act is done or the bill is dishonored. Currency. Where a bill drawn out of but payable in Canada, and the sum payable is not expressed in the currency of Canada, the amount shall, in the absence of an express stipulation, be calculated according to the rate of exchange for sight drafts at the place of payment on the day the bill is payable. Due date. Where a bill is drawn in one country and is payable in another country, the due date thereof is determined according to the law of the place where it is payable. Official images and electronic presentment. Definitions. The following definitions apply in this section in sections 163.2 to 163.6. Bank has the same meaning as in section 164. Eligible bill means a bill that is of a class specified by a bylaw, a rule, or a standard made under the Canadian Payments Act. Official image in respect of an eligible bill means an image of that eligible bill created by or on behalf of a bank in accordance with bylaws, rules, or standards made under the Canadian Payments Act, together with any data in relation to the eligible bill prepared in accordance with those bylaws, rules, and standards, and includes a display, a printout, a copy, or any other output of that image and that data created by or on behalf of a bank in accordance with those bylaws, rules, and standards. Status of official image. An official image of an eligible bill may be dealt with and used for all purposes as though it were an eligible bill. Electronic presentment. Despite anything in this act, a bank may present for payment an official image of an eligible bill electronically in accordance with bylaws, rules, or standards made under the Canadian Payments Act, and if it does so, the requirements of this act respecting the presentment for payment of the eligible bill are deemed to have been complied with. Discharge by payment. The eligible bill and its official image are discharged if payment in due course is made by or on behalf of the drawee after the electronic presentment for payment of the official image of the eligible bill. Presumption. 163.4. In the absence of evidence to the contrary, a document purporting to be an official image of an eligible bill is presumed to be an official image of the eligible bill. Admissibility. An official image of an eligible bill is admissible in evidence for all purposes for which the eligible bill would be admitted as evidence without proof that the official image was created by or on behalf of a bank in accordance with the bylaws, rules, or standards made under the Canadian Payments Act. True copy of contents. In the absence of evidence to the contrary, an official image of an eligible bill is presumed to be a true and exact copy of the contents of the eligible bill. Effect of destruction. If an eligible bill is destroyed in accordance with bylaws, rules, or standards made under the Canadian Payments Act, and there is an official image of the bill, a person's rights and powers in relation to the eligible bill are not affected by reason only that the person does not possess it. The destruction does not affect any person's rights, powers, duties, and liabilities in relation to the eligible bill. And C. The eligible bill is not considered to be lost or to have been materially altered or intentionally canceled. Warranty. A bank that creates or purports to create an official image of an eligible bill or on whose behalf an official image of an eligible bill is created or purported to be created, warrants that the official image or the purported official image, as the case may be, was created in accordance with bylaws, rules, or standards made under the Canadian Payments Act, and that it accurately represents the eligible bill. Damages. Any person who has suffered damages as a result of a breach of the warranty has a cause of action for damages against the bank. Part 3. Checks on a bank. Definition of bank. In this part, bank includes every member of the Canadian Payments Association established under the Canadian Payments Act and every local cooperative credit society as defined in that act, that is a member of a central as defined in that act, that is a member of the Canadian Payments Association. Check. A check is a bill drawn on a bank payable on demand. Provisions as to bills apply. Except as otherwise provided in this part, the provisions of this act applicable to a bill payable on demand apply to a check. Check for deposit to account. Where a check is delivered to a bank for deposit to the credit of a person and the bank credits him with the amount of the check, the bank acquires all the rights and powers of a holder in due course of the check. Presentment for payment. Subject to this act, where a check is not presented for payment within a reasonable time of its issue, and the drawer or the person on whose account it is drawn had the right at the time of presentment, as between him and the bank, to have the check paid and suffers actual damage through the delay, he is discharged to the extent of the damage, that is to say, to the extent to which the drawer or person is a creditor of the bank to a larger amount than he would have been had the check been paid, and B. The holder of a check with respect to which the drawer or person is discharged shall be a creditor in lieu of the drawer or person of the bank to the extent of the discharge and entitled to recover the amount from it. And the holder, I'm going to read that again. B. The holder of a check with respect to which the drawer or person is discharged shall be a creditor in lieu of the drawer or person of the bank to the extent of the discharge and entitled to recover the amount from it. Okay. Reasonable time. In determining what is a reasonable time within the section, regard shall be had to the nature of the instrument, the usage of trade and of banks, and the facts of the particular case. Authority to pay. The duty and authority of a bank to pay a check drawn on it by its customer are determined by A. Countermand of payment, or B. Notice of the customer's death. Crossed checks. Crossed checks generally. Where a check bears across its face an addition of A. The word bank between two parallel transverse lines, either with or without the words not negotiable, or B. Two parallel transverse lines simply, either with or without the words not negotiable, that addition constitutes a crossing and the check is crossed generally. Crossed specially. Where a check bears across its face an addition of the name of a bank, either with or without the words not negotiable, that addition constitutes a crossing, and the check is crossed specially and to that bank. By drawer. A check may be crossed generally or specially by the drawer. By holder. Where a check is uncrossed, the holder may cross it generally or specially. Varying. Where a check is crossed generally, the holder may cross it specially. Words may be added. Where a check is crossed generally or specially, the holder may add the words not negotiable. By bank for collection. Where a check is crossed specially, the bank to which it is crossed may again cross it specially to another bank for collection. Changing crossing. Where an uncrossed check or a check crossed generally is sent to a bank for collection, it may cross it specially to itself. Uncrossing. A crossed check may be reopened or uncrossed by the drawer writing between the transverse lines the words pay cash and initialing the same. Material part. A crossing authorized by this act is a material part of the check. Altering crossing. It is not lawful for any person to obliterate or, except as authorized by this act, to add to or alter the crossing. Cross to more than one bank. Where a check is crossed specially to more than one bank, except when crossed to another bank as agent for collection, the bank on which it is drawn shall refuse payment thereof. Liability for improper payment. Subject to subsection 2, where the bank on which a check cross is described in section 171 is drawn, nevertheless pays the check or pays a check crossed generally otherwise than to a bank, or, if crossed specially, otherwise than to the bank to which it is crossed, or to the bank acting as its agent for collection, it is liable to the true owner of the check for any loss he sustains owing to the check having been so paid. Payment in good faith and without negligence. Where a check is presented for payment that does not at the time of presentment appear to be crossed, or to have had a crossing that has been obliterated, or to have been added to or altered otherwise than as authorized by this act, the bank paying the check in good faith and without negligence shall not be responsible or incur any liability, nor shall the payment be questioned by reason of the check having been crossed, or of the crossing having been obliterated, or having been added to or altered otherwise than as authorized by this act, and of payment having been made otherwise than to a bank, or to the bank to which the check is or was crossed, or to the bank acting as its agent for collection, as the case may be. Whew! I mean, they're basically, it's always good to go back to that's what makes a payment in good faith without negligence. Protection in such case. where the bank on which a cross check is drawn in good faith and without negligence pays it, if crossed generally, to a bank, or if crossed specially to the bank to which it is crossed, or to a bank acting as its agent for collection, the bank paying the check, and if the check has come into the hands of the payee, the drawer shall respectively be entitled to the same rights and be placed in the same position as if payment of the check had been made to the true owner thereof. Okay. Not negotiable cross. Where a person takes a cross check that bears on it the words "not negotiable," he does not have and is not capable of giving a better title to the check than the person from whom he took it had. Customer without title. Where a bank, in good faith and without negligence, receives for a customer payment of a check crossed generally, or specially to itself, and the customer has no title or a defective title thereto, the bank does not incur any liability to the true owner of the check by reason only of having received that payment. Part 4. Promissory notes. Definition. A promissory note is an unconditional promise in writing made by one person to another person, signed by the maker, engaging to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. Endorsed by maker. An instrument in the form of a note payable to the maker's order is not a note within the meaning of this section, unless it is endorsed by the maker. Pledge of collateral security. A note is not invalid by reason only that it contains also a pledge of collateral security with authority to sell or dispose thereof. Inland note. A note that is, or on the face of it purports to be, both made and payable within Canada is an inland note. Foreign note. Any other note is a foreign note. Delivery. A note is inchoate and incomplete until delivery thereof to the payee or bearer. Okay. Joint and several liability. A note may be made by two or more makers, and they may be liable thereon jointly or jointly and severally according to its tenor. Individual promise. Where a note bears the words "I promise to pay" and is signed by two or more persons, it is deemed to be their joint and several note. Demand note presentment. Where a note payable on demand has been endorsed, it must be presented for payment within a reasonable time of the endorsement. Reasonable time. In determining what is a reasonable time, regard shall be had to the nature of the instrument, the usage of trade, and the facts of the particular case. Endorser discharged. Where a note payable on demand that has been endorsed is not presented for payment within a reasonable time, the endorser is discharged, but if it has, with the assent of the endorser, been delivered as a collateral or continuing security, it need not be presented for payment so long as it is held as such security. Not deemed overdue. Where a note payable on demand is negotiated, it is not deemed to be overdue, for the purposes of affecting the holder with defects of titles of which he had no notice, by reason that it appears that a reasonable time for presenting it for payment has elapsed since its issue. Presentment at particular place. Where a note is, in the body of it, made payable at a particular place, it must be presented for payment at that place. Liability of maker. In the case described in subsection 1, the maker is not discharged by the omission to present the note for payment on the day that it matures, but if any suit or action is instituted thereon against him before presentation, the costs thereof are in the discretion of the court. Note payable generally. When no place of payment is specified in the body of the note, presentment for payment is not necessary in order to render the maker liable. Liability of endorser. Presentment for payment is necessary in order to render the endorser of a note liable. Presentment at particular place. Where a note is, in the body of it, made payable at a particular place, presentment at that place is necessary in order to render an endorser liable. Presentment elsewhere. When a place of payment is indicated by way of memorandum only, Presentment at that place is sufficient to render the endorser liable, but a presentment to the maker elsewhere, if sufficient in other respects, shall also suffice. Effect of being maker. The maker of a note, by making it, engages that he will pay it according to its tenor, and B is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. Application of Act to notes. Subject to this part, and except as provided by this section, the provisions of this Act relating to bills apply, with such modifications as the circumstances require to notes. Terms corresponding. In the application of the provisions of this Act relating to bills, the maker of a note shall be deemed to correspond with the acceptor of a bill. The maker of a note shall be deemed to correspond with the acceptor of a bill. So if you make a note, that's the same as accepting a bill. Okay. And the first endorser of a note shall be deemed to correspond with the drawer of an accepted bill payable to drawer's order. Provisions inapplicable. The provisions of this Act with respect to bills and relating to A. Presentment for acceptance, acceptance under protest, and bills in a set do not apply to notes. Protest of foreign notes. Where a foreign note is dishonored, protest thereof is unnecessary except for the presentation of the liabilities of endorsers. Okay. Part 5. We have consumer bills and notes. Definitions in this part. Consumer purchase means a purchase, other than a cash purchase, of goods or services or an agreement to purchase goods or services. A. By an individual, other than for resale or for use in the course of his business, profession, or calling. And B. From a person who is engaged in the business of selling or providing those goods or services. Goods means any article that is or may be the subject of trade or commerce, but does not include land or any interest therein. Purchaser means the individual by whom a consumer purchase is made. Seller means the person from whom a consumer purchase is made. Services include repairs and improvements. Consumer bill. A consumer bill is a bill of exchange issued in respect of a consumer purchase and on which the purchaser or any person signing to accommodate the purchaser is liable as a party, but does not include a check that is dated the date of its issue or prior thereto, or at the time it is issued it is post-dated not more than 30 days, or B, a bill of exchange that would be a check within the meaning of Section 165, but for the fact that the party on which it is drawn is a financial institution, other than a bank that as part of its business accepts money on deposit from members of the public and honors any such bill directed to be paid out of any such deposit to the extent of the amount of the deposit, and 2 is dated the date of its issue or prior thereto, or at the time it is issued is post-dated not more than 30 days. Consumer note. A consumer note is a promissory note issued in respect of a consumer purchase, and B, on which the purchaser or anyone signing to accommodate him is liable as a party. Presumption as to issue. Without limiting or restricting the circumstances in which, for the purposes of this part, a bill of exchange or a promissory note shall be considered to be issued in respect of a consumer purchase, a bill of exchange or a promissory note shall be conclusively presumed to be so issued if A. The consideration for its issue was the lending or advancing of money or other valuable security by a person other than the seller, in order to enable the purchaser to make the consumer purchase, and B, the seller and the person who lent or advanced the money or other valuable security were, at the time the bill or note was issued, not dealing with each other at arm's length within the meaning of the Income Tax Act. Application of Act to consumer bills and notes. Except as otherwise provided in this part, the provision of this Act applicable to bills of exchange and checks apply, with such modifications as the circumstances require to consumer bills, and those applicable to promissory notes apply to consumer notes, with such modifications as the circumstances require. consumer bill or note to be marked. Every consumer bill or consumer note shall be prominently and legibly marked on its face with the words consumer purchase before or at the time when the instrument is signed by the purchaser or by any person signing to accommodate the purchaser. Effect where not marked. A consumer bill or consumer note that is not marked as required by the section is void, except in the hands of a holder in due course, without notice that the bill or note is a consumer bill or consumer note, or except as against a drawee without that notice. Rights of holder of consumer bill or note. Notwithstanding any agreement to the contrary, the right of a holder of a consumer bill or consumer note that is marked as required by Section 190 to have the whole or any part thereof paid by the purchaser or any party signing to accommodate the purchaser is subject to any defense or right of set-off, other than counterclaim that the purchaser would have had in an action by the seller on the consumer bill or consumer note. Obtaining signature to unmarked instrument. Every person who, knowing that an instrument other than an instrument described in paragraph 189, 1a or b has been, is being, or is to be issued in respect of a consumer purchase, obtains the signature of the purchaser or of any person signing to accommodate the purchaser to that instrument without its being or having been marked as required by Section 190 is guilty of A, an offense and liable on summary conviction to a fine not exceeding $1,000, or B, an indictable offense and liable to a fine not exceeding $5,000. Well, so if it's a consumer bill or note, make sure you write consumer purchase on it. Transfer of unmarked consumer bill or note. Every person who, knowing that a consumer bill or consumer note not marked as required by Section 190 is a consumer bill or consumer note, transfers it is, unless he is the purchaser or any person signing to accommodate the purchaser, guilty of A, an offense and liable on summary conviction to a fine not exceeding $1,000, or B, an indictable offense and liable to a fine not exceeding $5,000. Okay, so make sure you write consumer purchase when it's a consumer purchase on the bill or note. Schedule, Section 124. So now these are template notes, or let me not say notes, because that means something else. And these are letters that if you're doing one of these things, for example, noting for non-acceptance, that you can use and prescribed by the law to send to the person that you're sending it to. So the first one is noting for non-acceptance. Copy, so you attach a copy of the bill and the endorsements. So on the whatever day of whatever month of whatever year, the above bill was by me at the request of the drawer presented for acceptance to EF, the drawee, personally or at his residence, office, or usual place of business in the city, town of wherever, and I receive for answer, I'm not accepting it. The said bill is therefore noted for non-acceptance, and then you have the notary sign it. Due notice of the above was served by me on, and then this is what the notary signs. The drawer or endorser personally on the blank day of whatever year or at his residence in wherever it is on whatever day it was, or by depositing such notice directed to him in Her Majesty's, I guess wherever you would send it to in the post office, in the city of wherever it is, on the whatever day. So you could use this and fill in the blanks. Form number 2, protest for non-acceptance or for non-payment of a bill payable generally. So again, you copy the bill and the endorsements on this whatever day of whatever year, I, the notary public, for whatever province, dwelling at wherever I'm dwelling, at the request of the drawer or endorser, did exhibit the original bill of exchange, whereof a true copy is above written onto EF, the drawee or acceptor, therefore personally or at EF's residence, office, or usual place of business in wherever it is, and speaking to EF or whoever you spoke to, did demand acceptance or payment thereof, unto which demand he or she answered, I'm not paying, I'm not accepting. Wherefore I, the said notary, at the request aforesaid, have protested, and by these presents do protest against the acceptor, drawer, and endorsers, or drawer and endorsers of the said, drawer and endorsers, or drawer and of the said bill, and other parties thereto or therein concerned, for all exchange, re-exchange, and all costs, damages, and interest present and to come for want of acceptance or payments of the said bill, all of which I attest by my signature. Form 3. Protest for non-acceptance or for non-payment of a bill payable at a stated place on this whatever day, I, the notary public, for the province, wherever I am, at the request of whoever, did exhibit the original bill of exchange, whereof a true copy is above written unto EF, the drawee or acceptor, at wherever it was, being the stated place where the said bill is payable, and there speaking to whoever did demand acceptance or payment of the said bill, unto which demand he answered, wherefore I, the said notary, at the request aforesaid, have protested, and by these presents do protest against the acceptor, drawer, and endorsers, or drawer and endorsers of the said bill, and all of the parties thereto or therein concerned, for all exchange, re-exchange, cost, damages, and interest present and to come for want of acceptance or payments of the said bill, all of which I attest by my signature. Form number 4. Protest for non-payment of a bill noted, but not protested for non-acceptance. If the protest is made by the same notary who noted the bill, it should immediately follow the act of noting and memorandum of service thereof, and begin with the words and afterwards on, etc., continuing as in the last preceding form, but introducing between the words did and exhibit the words again, and in a parenthesis between the words written and unto the words and which bill was by me duly noted for non-acceptance on the whatever day. But if the protest is not made by the same notary, then it should follow a copy of the original bill and endorsements and noting marked on the bill, and then in the protest introduce in parentheses between the words written and unto the words and which the bill was on the whatever day by such and such notary, wherever the notary is noted for non-acceptance as appears by his note thereof marked on the said bill. Form 5. Protest for non-payment of a note payable generally. On this whatever day and whatever year, I, the notary public for the province of the dwelling at wherever the notary is, at the request of the drawer, did exhibit the original promissory note, whereof a true copy is above written unto the promisor personally or at the promisor's residence, office, or usual place of business, in unto personally in and speaking to the promisor or whoever did demand payment thereof, unto which demand he or she answered, I'm not paying. Wherefore I, the said notary, at the request aforesaid, have protested, and by these presents do protest against the promisor and endorsers of the said note, and all other parties thereto or therein concerned, for all costs, damages, and interest present and to come for want of payment of the said note, all of which I attest by my signature. Form 6. Protest for non-payment of a note payable at a stated place. On this whatever day of whatever year, I, the notary public of the province of wherever, at the request of the drawer or the not the promisor, the promisee or the endorser, did exhibit the original promissory note, whereof a true copy is above written unto the promisor at his place, being did demand unto which he answered, I ain't paying. Wherefore I, the said notary, at the request of the aforesaid, have protested, and by these presents do protest against the promisor and endorsers of the said note, and all other parties thereto or therein concerned, for all costs, damages, and interest present and to come for want of payment of the said note, all of which I attest by my signature. Notarial notice of a noting, or of a protest for non-acceptance, or of a protest for non-payment of a bill. Place and date of noting. First, to PQ, the drawer. I like these little not acronyms, initials, I guess. Sir, your bill of exchange for $10,000 dated at whatever day on EF in favor of, I guess that's a drawee, in favor of payable 10 days after cider date was this day at the request of EF. Duly noted or protested by me for non-acceptance or non-payment. So that's the first notice, and then the second notice to the endorser. So you send one to the drawer, and then you send one to the endorser, or FG. Who the hell is FG? You didn't say who FG is. Maybe another endorser? Sir, Mr. PQ's bill of exchange for whatever, dated at whatever, on EF, drawn on EF, in your favor, payable so many days after cite, and by you endorsed, was this day at the request of, by me, okay. Notarial notice of protest for non-payment of a note to such and such, sir. Mr. PQ's promissory note for $10,000 dated to whatever day, payable so many months after date or on a specific date to you, EF, or order endorsed by you, was this day at the request of, duly protested by me for non-payment. Notarial service of notice of a protest for non-acceptance or non-payment of a bill or note, and afterwards I to be subjoined to the protest. Notice of protest. So subjoined to this. Notice of a noting. So where do we start? So at Form 1, noting for non-acceptance. Protest for non-acceptance. Protest for non-acceptance. Protest for non-payment. But not protested for non-acceptance. Protest for non-payment. Protest for non-payment. Notarial notice of a noting or of a protest or non-acceptance. Notarial notice, okay, of a bill. Non-payment of a note. Notarial service. So we have a notarial notice, and then we have a notarial service of notice of a protest for non-acceptance or non-payment. For protested on the jar, depositing such notice directed in Her Majesty's Post Office in testimony where I have on the last mentioned area are signed these presents. Protest by a justice of the peace where there is no notary for non-acceptance of a bill or non-payment of a bill or note. On this such and such day and such of that year, I, I don't get these. I mean, I know they're just putting something there, but why wouldn't it be like JP, the Justice of the Peace? I, the Justice of the Peace, one of Her Majesty's Justices of the Peace for the district of, wherever of, in the province of, dwelling at or near in the said district, there being no practicing notary public at or near the village, or any other legal cause, did at the request of, and in the presence of, blank, well known unto me, exhibit the original bill or note whereof a true copy is above written unto PQ, the drawer, acceptor, or promisor, thereof, personally or at PQ's residence, office, or usual place of business in wherever, and speaking to PQ, or did demand payment or acceptance thereof, unto which demand he or she answered, I am paying. Wherefore I, the said Justice of the Peace, at the request of the aforesaid, have protested, and by these presents do protest against the drawer and endorsers, promisor and endorsers, or acceptor, drawer and endorsers of the said bill or note, and all other parties thereto and therein concerned, for all exchange, re-exchange, and all costs, damages, and interest, present and to come, for want of payment or acceptance of the said bill or note. All of which is by these presents attested by the signature of the said, the witness, and my hand and seal. Okay, so and then they sign it. So these forms are really interesting to study. I mean, it kind of puts into practice everything said in the Bill of Exchange Act. You know, that first creating the bill. So I'll probably do a video where I kind of lay this out to the best of my understanding, what a bill will look like. Obviously a bill can look like anything. Like I said, you could just write it on a blank sheet of paper and just write an amount into who it's from, or even just put your signature on a paper and then someone can fill in all of the other things. So essentially, you have your drawer, your drawee, and your payee. So your drawer, it's Bob. Then you have Bob's Bank, and then you have Joe's Plumbing. And so Bob draws up a or actually that could be one way of a bill of exchange. But the other one is that Joe's Plumbing is the drawer, Bob is the drawee, and the payee is Joe's Plumbing. And then Bob accepts the bill and endorses the bill back to Joe's Plumbing so that they can go and receive payment for the bill. But obviously I have to work that out. It's definitely a little convoluted, but I wanted to read through this so I can listen back to it when, if I just didn't want to read. Sometimes if you're just reading it, especially all this legal lingo, it can, be hard to go through. But if you're like me and you're having to study this act, hopefully it's helpful. I'll be reading other things and diving more into this topic as I learn more about it. I hope you enjoyed that. And I know this is not the most exciting videos, but hopefully if you're studying this, for whatever reason that you're studying this, we can study this together along with other things that I'll be doing a similar thing for. So thanks for watching. This is part 2. You can see part 1. It will be linked down below. And I'll also have this in a playlist with the 2 videos. You can watch them back to back, where I'll go through the entire Bill of Exchange Act. Thanks for watching.